back into order, please. We recognize our guests. We've already, I guess Mr. Newton, y'all want to acknowledge yourselves?
I'm good.
We've heard that, Charlie.
Ma'am, would you like to address us, or you good? Okay, thank you. All right. First thing we would like to do is go ahead, in your documents that you had downstairs in the chamber, you would see the minutes from our October 15th meeting. If you have not had a chance to review those, please do. And if you have, and someone wants to make a motion to approve those minutes, we will do that at this time when you're ready.
I'll move.
All right.
I'll second.
Okay, got a second. Any discussion? All in favor, show of hands, please. All right, passes unanimously. Minutes are approved. Okay. At this time, we'll go ahead and start our review of the city charter, Article 1, dealing with incorporation and territories. And I guess, Mr. Smith, is there any particular way that we should do this?
I guess we can just go section by section, and you can see what we've provided, and then if you have questions or you have any other items on, that way we can just check off the section as we go. That's probably the easiest thing to do. Okay, first of all, I want to make sure everybody was able to read the red line that we sent out.
Can I ask a question before we start?
Yes, ma'am.
So the red lines that you send out, are they from a legal perspective, or are they from a basically cleaning up perspective?
They're from a, as the comment should indicate, it's either cleanup or to, mostly it's cleanup to conform to state law or elimination of redundant language.
Okay.
And so if we're already in a section, we're making some substantive change, we maybe try to clean up the language, but like we talked about last time, we don't want to sit there and correct grammar unnecessarily unless we really need to, so.
I just want to understand the basis when we get the red lines, kind of where they're coming from. So you are
Right.
looking at it from a state perspective and then also from
Right.
redundancy.
Right, because I've had the benefit of staff comments and do it in keeping with the charge of the council, what they wanted to see done. But that doesn't mean that as you go through section by section, you find something, you have a question you want to change, we certainly can consider that. But the whole idea is to stay with that charge and not rewrite things just to rewrite it. That's why there may be some awkward language in there, but if it reads okay and it's understandable, then we leave it alone. If it's, because a lot of this language is since 1956. So.
Okay, thank you.
So being said another way, the red line that we have a chance to look at would be offering up technical changes, if you will.
Yes, sir. What we put out to you and what I understand was available on the website and available to the public as well, right, Amy?
This is not on there.
Oh, it's not on there, okay. Is basically technical changes that we're recommending to you.
So the ones we have in hand are the same, identical to the ones that we got last time? So we have two copies of the same thing?
Yes.
Yes.
Yes, ma'am. Yes, ma'am. And we'll do that each week, whatever our assignment is. In the packet that comes out from the city staff will be those, like I think next week we're going to do Articles 9 and 10.
Correct.
So on Friday when the packet goes out, you'll get a red line of what we think you ought to consider for Articles 9 and 10. But that's not to say that you can't raise anything as we go along.
And are these your comments out to the side?
Yes, ma'am.
Okay.
There are collective comments, not law firm's comments, so. But I want to make sure everybody was able to read it and, okay, okay. Because I have a hard time sometimes reading the comments.
Pete, we're landlocked, and so the annexation comments in here are usually border adjustments.
Right.
Which usually include a de-annexation and an annexation. Are those covered under the same legal area there, so we don't have to mention?
Yes, so that's covered by state law, and in addition, there's a provision state law allows cities to adjust boundaries by agreement, which we have done with Plano, and I think just with Plano. We may have done that with Garland one time.
Okay,
So,
thanks.
so as we go through, unless anybody has any questions about section 101, that's fine. The next
Yeah.
section?
Well, Pete,
Yes, sir.
sorry. I noticed in 101, the second word is inhabitants. And then I noticed down at the end, the last sentence of 103, that we refer to them as residents and then refer to them as citizens. And while inhabitants and residents could be arguably the same group, not all of them are going to be citizens. And I was wondering if that could potentially somehow, somewhere cause confusion in someone's mind that we're giving the rights of citizens to people who are merely inhabitants or residents. Why is it really necessary to have three different terms there? And which one do we mean?
Well, I didn't change 101 because the language is okay.
Sure.
And you're talking about 103 where
The
we,
last sentence refers to residents and citizens, and it's the same body, obviously, as inhabitants in 101, and yet you could understand that residents, citizen, and inhabitants are not all the same thing.
when we get there, we can change residents and inhabitants, we can change that. That's-
Okay. Well, I just thought I'd point it out now since, 101 and 103 together. Okay.
Okay. All right, so section 102 is about the boundaries. As the comment indicates, chapter 41, the local government code requires city secretary to maintain an official map of the boundaries. So this is simply a cleanup and get it with the more current state of the law. Hearing no comments, we'll go to 103. In section 103, we eliminated some unnecessary requirements that's not required under state law and make the process easier and cleaner. And if you want to talk about the additional text at the end there, we can change residents to inhabitants. It's your pleasure. That's language that you'll find in other city charters. So it's fairly standard language, but there's no legal conflict because if one place you say inhabitants, one place you say citizens or residents.
I don't have the entire charter before me, but none of these are defined terms of it.
No,
Okay.
no, they're not defined terms.
Oh, and I meant to start my comment by saying, Pete, thank you very much for excising the large sections of the thing that's no longer needed. This is definitely the way the charter needs to move.
Right, so we may end up having lots of propositions to do that, but, it's about time we cleaned up some unnecessary language. So, unless there's any other comments on 103, we can go to the next.
So we're leaving citizens there?
You tell me what y'all want to do.
At what point do we need to make a motion, or if no motion is made, then we move on? Is this-
Well, I think we'll just go
What
section
would
by
be the
section,
program?
and then, once we get to a place where we have some changes to make, so or we can do each one. So, I guess that's the easiest way to do, just one call for motion on 102.
Why don't we say by article? You want to go by article? Let's do Article 1, then Article 2, and then within the sections of each. That way we could,
Well, if you do, I don't mean to disagree with you. If you do section 102, there's only one section 102. So if we can just get a motion on each section as we go through.
okay, so what, if I understand this correctly, we want to have a motion on the table that section 101 is as written, and we want to move forward on that.
I move that we approve section 101 as presented.
Okay, is there a second? Any additional? Okay, Eric, a second. Is there any additional comments, thoughts? Okay, show of hands in favor, 101. All right, passes unanimously. Section 102, in regards to boundaries. Everyone comfortable with that?
We need a motion to
So,
recommend.
Okay, Jason has a motion
I
to
would so move for
accept.
approval of 102 as written with the red line changes.
Okay, is there a second?
I'll second.
Okay, all the seconds, any discussion? None, okay, all in favor? Okay, passes unanimously, thank you. Okay, section 103, additional territory.
Okay, I'm still not excuse me.
Yes, ma'am, Nancy, go ahead.
I'm still not clear on whether we're using citizen as inhabitant, or does that include? Are
This
we
is the time to
defining
discuss it.
citizen as a citizen, or are we defining inhabitant as a citizen? Are we treating these as the same term, or are they two different, and is that intentional?
Well, I think one thing I read, it said future residents. So I think that's different than an inhabitant or a current citizen, because the word future is in front of it. Is
Well,
that correct?
it says residents and future residents. I would be happy, since I brought this up, if we just change citizens to residents. As people point out to us, it does say subject to state and local laws and regulations, so there's a limit to what that could mean. But with the whole farmers branch thing and whatnot, where there's a whole argument about who's a citizen, who's not, things like that. Let's just make it simple. If we mean all the inhabitants and residents, let's just say only that and drop the word citizen, because as Nancy said, do we trying to suggest it's a different word or not? Well, let's don't use it if it's not clear.
It looks like what was attempted was to make a differential decision between residents, future residents, meaning the annexation issue, and then goes on to say the privileges of other citizens. That's the thing that I get caught on, is that the word citizen there implies that there's a higher order somewhere in there, and I don't think that was the intent.
Right, I don't think so.
So what if we went with just residents, and use that?
We get to do that. That's your call. You could change citizens to other residents of the city. It's really inconsequential. Your point's well taken about the farmers branch. So
You make a motion, I'll second.
Well, I just wanted to see if there's any more discussion. Okay, in that case, Mr. Chairman, I'd like to move that we approve section 103 as presented, with the exception of the amendment of the word citizen in the last line be changed to residents.
Okay.
Second?
And a second by John. Any discussion? Okay, all in favor, show of hands, please. Passes unanimously.
Mr. Chairman, and I apologize.
Yes, sir.
I'd like to take us back to the motion that pertains to section 102, as it was stated. It referenced red line, but aren't there some underlying language in bold that's new words in there? And would we get caught up if we just focused on the red line, which would be my...
no, I think the motion was to approve 102 as recommended.
Okay.
So
So it wasn't referencing red line?
And I didn't reference the underlying language there, but I understand what you're about.
No problem.
Okay.
Can I just get a clarification on the last motion? We're changing citizen in the last sentence to
Residents.
Okay.
Yes, ma'am. Okay. Article 2, powers of the city, section 201. Thoughts, comments? All right, hearing none, let's move on to section 202. Okay, I'm sorry, yes. Thank you, Kim. Okay, got a motion?
Move for approval as presented.
Okay, got a second. Bill seconds. Any discussion? Okay, all in favor, show of hands, please. Passes unanimously. As stated. Okay, section 202. Do we need any clarification on home rule amendments to the Constitution of the state of Texas? Is that?
No, and what those two sections does is refer to the Texas Constitution, that when we, of a certain size, when we vote in a home rule charter, saying that we have all the powers of a home rule city, and we have full power of self-government, except as limited by the Constitution and the statutes of Texas. So those two sections are very standardized language, and what it does is it empowers the city to do everything it possibly can within the confines of the Constitution.
All right, anyone want a motion to approve as written? Kim makes a motion, Jason seconds. Any further discussion? All in favor, show of hands, please. Passes unanimously as written. Section 203, eminent domain.
And 203 was some archaic language, and so what we did was streamline it to indicate that we have the power of eminent domain that's conferred upon municipalities. We're not doing anything greater than what's allowed by state law, so it's not a case where we're trying to condemn public property. You can probably remember the controversy over the U.S. Supreme Court case, and which had been the law of the land for well over 50 years, so the Supreme Court didn't change anything in that case. But all it's saying is we have the full power of eminent domain to acquire property in or outside the city in accordance with state law.
I have a minor little thing.
Yes,
We
ma'am.
sometimes capitalize city when we talk about the city, and sometimes we don't.
Ah, good point.
So just to keep consistent, I have that. It's when we say city of Richardson, it's
Richardson is
capitalized,
capitalized.
but I've never.
But you
Well-
may find that as we go through the whole
Sometimes
chart.
it's capitalized when it says the city, da-da-da-da, and sometimes it's not. So I guess we just need to stay consistent one way or the other.
Right.
I wouldn't think so either, but, where was it? I just saw, or maybe it was in the former version.
In
I
102.
was trying to stay consistent to the extent I could, so I didn't capitalize it because in
And it's-
201 it wasn't capitalized.
And it's in the original version, not your marked up version, so that's where I had seen, those were my original marks, so.
If you look at 102, city's boundaries, see it. But if you look at 103, the second word is lowercase city. My style would make them all uppercase and referring to our city. But that just. Okay, we're still in 103? I'm sorry, 203?
We are on 203.
Um,
Do we need to make a motion
Why
to
don't we-
do out?
Why don't we come back at the end, because I think as we go through it, we'll see it inconsistently used, and then we can decide whether or not we want to have a global change
Mhm.
of uppercase.
It's a great idea.
So if we can just focus on the text of the substance of the change, and then make a note to come back at the end and say, we want to change grammar, do we want to change capitalization, so.
Okay.
Okay, Pete, I did have a question.
Yes, sir.
The fifth line here says, "The right of the city to take the fee in land so condemned." I take it that's a precise legal phrase?
Yes.
Because it sure struck me as odd at first, but I realized it must be a
Yes.
precise legal.
I mean, fee refers to the fee simple title, which includes
Right.
all the bundle rights and property versus an easement.
Mhm.
And sometimes we condemn an easement, sometimes we condemn the entire property,
Right.
and so that's very standard
That's fine.
language.
If there's no other comments, I'll move that we approve section 203 as presented.
As recommended?
Or is that not the same as
No,
presented?
that's fine. That's
Okay.
fine.
Okay. Do we have a second? Okay. No further discussion?
Let me ask you a question
Yes,
before
John.
we do the final vote on that. And Pete, I guess
Yes, sir.
you're the guy that can best determine this, but is there anything with eminent domain still in flux? In other words, this follows the current law. Is there anything about to change in eminent domain that you're aware of, either administratively or anything like that in the works?
I'm not aware that the legislature, I'm not aware that that's a topic.
Nothing was left undone from the last time?
No, I mean,
There was no...
they've made it clear that you can't condemn property for economic development purposes.
That's
That hasn't changed.
Right.
But whatever they do, what this does is, whatever the legislature may do in the future allows us to take advantage of it or be more restrictive if the legislature makes it more restrictive.
Okay, very good.
Okay, we have a motion and a second. All in favor? Passes unanimously. Okay. 102, section 2.01.
20?
20.
20.
20?
20.01. Thank you. I need to trust me.
Yeah, I can't tell you what the historical context of the language was, but basically, church and school is not exempt unless there's some statute that says that church and school property is not subject to taxes or some special assessment. So what we did was clean up the language and make it clear that they're not unless state law provides otherwise.
Pete, I did have a question. I know as a council, city council, and as the city manager's office, they work to get companies and people to come to our city. And sometimes we, as far as taxes, we do
We do
things to
we do
help
some
them.
tax abatements and what we call
Yes.
Chapter 380 agreements.
So in those agreements, is that something that's covered here, or is that a whole
Yeah.
different?
Because tax abatements are authorized by Chapter 312 of the tax code, and then Chapter 380 of the tax slope procurement code allows cities to provide economic development centers. So those devices that we use currently are authorized by state law, so that would not impair that in any way.
So the statement for state law allows us to do that?
Yes.
Okay.
This sentence confused me. If I take out charter and I just read taxes and assessments authorized by state law, except as authorized by state law.
We'll see here.
Authorized by this charter or state law, except as authorized by state law. It seems redundant or contradictory.
Looks like that last clause refers to the exemptions.
Okay.
It could be, otherwise,
That's a good point. How can state law authorize it if it's also exempting it?
We'll just read it out loud.
Well, there's,
No property of any kind, church, school, or otherwise, in the city of Richardson shall be exempt from any of the special taxes or assessments authorized by this charter
Oh,
or
okay.
state law, comma, except as authorized by state law.
what it's saying is if there's a tax or assessment that's imposed by the charter or by state law, that they're not exempt except by state law.
Okay, so
the
just
charter
way it
cannot
is.
exempt, is what you really saying.
No, I mean, we could do that. I mean, we could, I'm not sure why we would do that, but
I read it the wrong way, I thought.
Me too.
we could change except as authorized by state law to say except as provided by state law. That might be easier reading.
Well, the question I think that Erica had was bar state law, the first change there, because if you, we're not really referring to state law. It's not up to us whether the state law is exempt or not. It's only up to us what the charter does, except as authorized by state law. So, I mean, I don't know why we don't just drop out bar state law.
Well, because,
Go ahead.
go ahead, Joe.
I was gonna say perhaps state law allows us, we can make exemptions to a business
Sure,
for
that's what
things under state law, not just the charter, but under state law.
And well, so why is that in our charter?
You have to allow for it.
Yeah, it's actually in two places. It's the charter and the state law.
Okay, the state law is going to provide an exemption, like the state law is going to tax, except as authorized by state law. That was the original point. It's kind of like we're saying our state law except as authorized by state law. Well, we wouldn't have done it in the first
But
place.
the state can provide for a taxation or an assessment, but also provide for an
Sure.
exemption of it.
Sure, that's why the second
For example,
phrase is there.
For example, the real property and buildings of a church, regular sanctuary is exempt from property taxes, but not all of the property. Or school, for example, better example. A private school can be exempt from property taxes, the building and land, but not the tangible personal property. So,
Well, let's do what Marta did again. You know, no property shall be exempt by, for taxes and assessments authorized by state law, except as authorized by state law. Take out the charter. And then the sentence makes no sense. Or it's black cat, it's black.
So you're saying that from any special taxes or assessments except as authorized by state law?
Just take out or state law, those three words right after the word charter. Take it out, because why are we addressing whether or not, tax exemptions by state law? It shouldn't be in our charter. We should only reference our charter and then note except as authorized by state law.
That is not.
I think that last clause only refers to the exemptions that are authorized by state law. The first clause, after the word exempt, refers to the special taxes and assessments that are authorized by this charter or state law. Does that make sense? It makes sense to me.
It's a recognition that the legislature can actually step in and they can make abatements and they can make exemptions.
And we can't influence those, is basically what it's saying.
Correct.
So
Not to
is-
mention, it's kind of supremacy as
Yeah,
well, supremacy of state
exactly,
law.
exactly.
So is the second,
should be
except as
semicolon.
authorized by state law necessary? Or is it inferred by the first reference?
I think if we take out the second authorized and said, authorized by this charter or state law, except as provided by state law.
If you put a semicolon behind the first for state law, I think that clarifies the whole statement.
That's a good point.
That's a help.
That semicolon where, Amy?
After state law.
After or state law, semicolon, except as authorized by state law.
It's like a semicolon, however.
Yep.
Okay. It just causes confusion.
Right.
I think a
It's repetitive.
semicolon,
It's repetitive.
it's repetitive. I
Yes,
think a
using the word
semicolon would help
authorized.
break the thought.
But I wonder with Pete's suggestion too about changing the second authorized to provided. So if you do authorized by the charter or state law, semicolon, except as provided by state law,
It's easier reading.
it's a little easier reading in addition to the semicolon.
Yeah, that's
Okay.
I agree.
I like that.
All right.
Okay. Well done, gang.
We like
that.
There's absolutely no pride in authorship. I'm trying to change as few words as possible. So
I'm thinking that's just a precursor of things to come.
there'll be some long nights.
I like the citizen, inhabitant, and resident.
No blood has been shed yet.
Okay, I think we kind of came to a consensus. Anyone want to capture that and make a motion, please?
I make a motion to approve with the addition of the semicolon and replacing authorized with provided.
Second that.
Second by John. Okay.
Just to be precise, the semicolon goes after the phrase state law and before except, and then it's the last authorized that's changed to provided.
Correct.
Just
Yes,
to make sure that Amy got
I
that.
have.
Okay.
Okay, any further discussion? Show of hands in favor, please. Passes unanimously. All right, 20.02, notice of damage or injury.
This section refers to notice of claim that a injured person or property owner would have to give the city in order to perfect a claim prior to filing a lawsuit. I know the lawyers here will be quite familiar with that. And so what we did was we cleaned up the language and streamlined it to be more consistent with it's actually chapter 101, Texas Civil Practice Remedies Code. So with that, I'll answer any questions. We haven't taken anything away from anybody. We've just cleaned up the language. And the last sentence is added to clarify that even if you give a notice of claim of damage or injury, we haven't waived any claim to immunity that the city has under state law.
I'll be honest, I found the first sentence virtually unreadable, and I kept moving commas around, trying to find a subject and a verb and an object.
So, Bill, you're violating the first rule that I'm following, and that is try not to change too many words. Just try to clean it up.
You need to read the Tort Claims Act in its entirety. It's not very well
It
written.
just, I just make that observation that it's unreadable in its present form.
And part of the problem with the original language is that it has two separate clauses in which it deals with personal injury and it deals with damage to property. I think changes actually encapsulate
Right.
what we're trying to do, but it does a lot more concisely.
What does my notes on this were, that a lot of it is repetitive, the original
Right.
version,
Right.
But what does it taking it down so much further do to the intent? Because you know, in the original version, we're talking about 6 months and 24 hours, and again, it might be too much. But now there's less of that, so we're trying to make it a little bit broader. I mean, does this broaden, does the new version broaden the intent?
As Jason indicated, it was redundant because it talked about injury, then talked about property damage. That's one thing it did.
Okay,
Eliminated the 6-month provision because that can be changed in the legislature.
okay,
And then the idea that we're not going to be liable unless we have 24-hour notice, that's inconsistent with state law.
okay. So it's.
And then, and Gerald, Jason may have some other comments on that. Most of the plaintiff's lawyers, most of the personal injury lawyers, they know what to do, and so they send a notice of claim to us, and they got to perfect that within that time period.
Okay. Any further discussion on that? Anyone want to make a motion? Jason?
We move that we adopt section 20.02 as recommended.
Do I have a second? Bill, second. Any further discussion? Hearing none, show of hands in favor, please. Passes unanimously. All right, 20.03.
What we did here was try to clean that up, and we do have garnishment of wages, we do have child support orders, and so it's incorrect to say that we're never required to allow that. So happy to answer any questions there.
The word absolutely preceding void at the end of that first paragraph there is the.
It's either void or it's not.
Yeah.
Yeah, I was gonna say, is that an emphasis by putting absolutely in there, or is that?
Well, John, you probably know because you've been around so long where absolutely came from, but and we can strike that too. I was like I said, my first rule was try not to change too much.
We
But
could
we
add
can-
an exclamation point if.
I want to see that proposition.
The word absolutely is probably overkill there, I would say.
And if we're going to change that section, we can take that out. I don't think citizens are going to go, oh my God.
I would agree with John.
All right, I'll make a motion to approve that section unless there's any other changes, without the word absolutely.
Second, further discussion? Show of hands in favor, please. Passes unanimously.
Save that word. Absolutely.
Absolutely. All right, section 20.04, liens on public property.
Is there any reason why that's not bolded like the other sections?
It may be just that's probably my preference.
It is bolded in the original.
Is it?
Yeah, it's bolded in the original.
Keith, is it really under state law okay to put lanes on property
No.
in those cities?
Can't.
So do we need to mention it here if state law doesn't allow it anyway?
You're, once again, Bill, you're violating my first rule. that-
Well, you're doing such a good job of getting rid of stuff that's already addressed by state law. I just wondered if this wasn't another thing addressed by state law, so why do we even have it here? Especially if the state ever changes the law to allow it in certain cases, then we'd have to have a charter amendment as opposed to, we'll just follow state law.
If they change state law, Bill, then we won't be able to override that with the charter saying,
I know, so the charter would be invalid and we have to change the charter, and so why do we even have this here if state law already prohibits it?
it wasn't inconsistent with state law.
Now,
I doubt that they'll ever be inconsistent with state law, so I'll look to Jason and Gerald if they got some comments. But once again, my first rule was,
I understand that.
if it's okay, leave it alone, so.
My rule, however, is to simplify, and if the state law already addresses this, then we should, because we know that's happened before, that we had stuff on our charter and state law did change, and we didn't change our charter, and it caught us. So, I don't know what the future holds, and since we're looking at it now, and it's a trivial change now, to simply delete the section, or to add, except as allowed by state law, which we've done in other places.
We don't want to do that.
What? Why not?
Either you leave it in or you take it out, I guess.
Okay.
The charter, to me, has a couple of different purposes. Number one, it's definitely an educational tool for any citizen who wants to read and find out what's going on.
That's a good point.
And secondly, it sets the ground rules for what's legal and what's not. So I'd like to err on the side of being more illuminating as to what the charter says. And if someone goes into the charter and says, well, I didn't know you couldn't file a lien or something, that's an educational experience for them. And so I think it does serve a purpose by having it in there. Unless there's a dire need to take it out.
My guess is it would probably serve as a barrier to mischief as well, thinking about Republic of Texas and some of the groups and
True.
things.
Well,
Good point.
I would just counter is that our charter currently states that the city council, the city may not sell debt without the approval of the voters. Okay, obviously, we've been selling debt without the approval of the voters because of the Act of Certificates of Obligation from 1971. So our charter said something that literally wasn't true anymore. And in fact, that caused a problem when someone came to complain to the council and suggest they all resign because they couldn't follow the charter. And it was not because the city was doing anything wrong, but someone read the charter and it was now out of sync with state law and they got confused.
We're not to that section.
Yes, I know, but this is another example of something that could get out of sync with state law. So why leave it in there to get out of sync with state law?
That's
You
why
say
you
that
do
about a lot of different
irregular.
things.
That's
Yeah.
why you do
Yeah.
maternity
Yeah.
leave.
Anything in here is at risk of being adverse to state
Well,
law.
as I asked Pete, doesn't the state prohibit this anyway, so why do we have it here?
But I think John and Jason make good points about mischief and informing the public. And, I would say, go ahead.
I think you'll find that throughout here, even with the notice under the Tort Claims Act, it's 6 months. But we have this provision in here as well. It's 6 months notice under 101 of the Tort Claims Act. A governmental unit is entitled to receive notice of the claim not later than 6 months. And it's not what's before us, but that's the state law.
You're referring to the section that's been removed?
No. I'm talking about the previous section. What I'm saying is that we may find that to be true throughout the charter, that there is a state law that provides for it, but we have it here as an additional barrier or notice to the citizens.
Oh, there it is, 6 months.
And I'm sorry, I was talking about
Yeah, I see.
20.02.
I see it now.
That's almost taken directly from the state law, 101.101. And so I think to tinker with that, we'd be here quite a bit. It's not harmful, I think it's helpful if anything.
Well,
further
I
plans.
would just repeat, well, I acknowledge what you're saying, and I acknowledge, Pete, that you don't want to have too many changes, I do understand, because it's going to be fixed.
Yeah, if you're gonna do anything with that, you change the language to say property of the city or public property, rather than public hall, parks, and public works. But like I say, it's not broke, it's not in conflict, it doesn't cause any problems, so.
I just want to be cognizant of the fact that the 1988 Charter Commission could have changed the language about voting on debt and didn't. And sure enough, it caught us. Now, it didn't catch us, we did nothing wrong, but there were citizens, in fact, an attorney who misread it and came and spoke to us about it. And I just want to avoid situations like that. If an attorney can misread it, how about the ordinary citizen? You see, that's.
But you know what they say about lawyers, right? They all have different opinions.
Are you sure?
That's not what we said about lawyers, in my mouth.
So anyway, that's the reason I'm harping on this, and I may harp on it again. It will come up on the section on debt, for sure.
Bill, why don't you put that down on your personal notes? And after we go through the whole thing, we're gonna go back through everything that we've discussed and approved. And if you wanna bring that back up then, we can discuss it then.
And just so we clarify, there's no harm done if anybody winds up on the wrong end of a 10-to-1 vote.
Absolutely.
So, I mean, this is all opinion basically based. And,
Well, not to be a dead horse, but are public halls, parks, and public works too restrictive considering things that qualify as city property?
It is. But like I said, I was trying not,
I-
it's adequate,
You
but
can
like I
throw things
say,
at me.
if you wanna change, if you were gonna change it, you'd be more inclusive.
Just be tempted to say the property of the city of Richardson.
yeah, that would
That's
be-
why we got other lawyers out here.
Or property real and personal of the
Well,
city of
sure,
Richardson.
real
Yeah, I-
personal
I-
property would cover everything.
Yeah, that's right. That's a good idea. I like that. What'd you say?
Does the city have personal property?
Yes.
Because personal
We stated
property is
You're sitting
property, it's
on
not
it.
real.
That's
right, yeah.
Any
That way it's
property that's not
consistent
real
with
is personal,
2003.
even if it's business. Confusing.
So what I heard was that 20.04 would be a change to no lien of any kind can ever exist against the real and I guess and.
I wrote property, comma, real and personal of the city of Richardson.
Just like it
Or
is.
property, both real and personal of the city of Richardson.
Property real and personal of the city.
Yeah, it's just like the first statement in section
Oh,
23.
Oh, yeah,
Yeah.
that's right.
No lien of any
For
kind
consistency.
can ever exist against the property, comma, real and personal of the city.
Helps with consistency as well.
All right. We're on a roll.
Okay, do we,
All
not
right.
that insult to injury, but do we help Bill out if we put except as provided by state or federal law? No lien of any kind can ever exist against.
No, because then I think what that does is suggest to some reader that, there must be something in state law. I think they say, we got you again.
It might be in 20 years.
And if they do, then the state law is going to trump it.
Yeah.
We'll be in the nursing home by then, Bill. Won't we?
Speak for yourself.
Jason, you want to put that in the form of a motion, sir?
You bet. I would so move, Mr. Chairman, that we adopt section 20.04 as provided, with the exception of striking the language public halls, parks, or public works, and replacing it with property, comma, real and personal, comma, City of Richardson.
Second.
Got a second? Okay, any further discussion? Okay, all in favor, show of hands. Passes unanimous. Okay. Article 21,
But 20.05.
20.20.
Yeah, section 20.05. We've got it read.
Got it.
And what we did there was that language is covered by
Yeah.
section,
You have to vote to agree to strike it.
got you, 21, I see.
20.05, we recommend deleting that since we've already covered that subject matter in section 20.02.
I will, oh, I'm sorry, I was
Okay.
going to move that too.
All right, Kim is so moved.
So moved that we're approving this.
You're so moved.
All right. We have a second? Any second? All right, any discussion?
I will note that you've established the principle that's okay to delete sections.
Yes,
Okay, thank you.
touche.
All right. All in favor, show of hands, please. Passes unanimously. Okay. Okay. Article 21. If you will note from the original that y'all sent out, the title is General Provisions. It's not the effective dates, and with a misprint. So you had that in, that was sent out electronically. This is what you need to look at here. Okay?
So the first one, section 21.01, personal financial interest. This is a fairly standard provision in city charters. It's also covered by, to some extent, by the Code of Ethics.
Is it on someplace else through an office?
No, it doesn't, and typically what, here we go. An officer under the case law is counsel and a member of a board or commission that performs quasi-judicial duties, more than a board or commission that's not advisory. So someone on the library board is not considered a city officer. We do define those in the Code of Ethics, clearly in the Code of Ethics. And I know that Bill, I know everybody's going to say, well, why don't we go ahead and define it? Well, that may change, and I'm not sure we can describe every single person. So when it comes up, you know, we have this person, clearly City Council, P&Z, Board of Adjustment, Building Standards Commission. Those folks are considered city officers for purposes of this section. And of course, obviously, employee is an employee, not an independent contractor. But we also have the Code of Ethics, which the council, I think the council just updated.
Correct, yes.
Yeah. And that goes in a lot of detail about it. So, once again, sticking with the premise, if it's not broken, it's not in conflict, leave it alone.
It's my impression that the Attorney General has pretty much defined what an officer is, because he writes opinions about that very subject constantly.
They do. And quite often, if an issue comes up, we have to go and look at all the AG opinions and case law because like I say, an officer is someone who has quasi-judicial responsibilities, who gets to perform their discretionary duties largely independent of others, such as the Planning and Zoning Commission, Board of Adjustment, Building Standards Commission. So.
Yeah, it's true, I like definitions, but in this case, the legislature and the Attorney General are pretty clear about what they think officers are. So I'm not really worried about it here.
Okay. Everyone good with that? Want to make a motion to accept as is? Nancy, got a motion on the table to accept as written. Jason, got a second. Any further discussion? Show of hands in favor, please. Passes unanimously. Thank you. Section 21.02.
2102 and 2103 are related, and what we're trying to do is clean up some language and make it consistent with state law and eliminate things that are not required by state law. In Richardson, we have administrative code where the council by ordinance has delegated authority to the city manager and city manager's designees, which are typically the ACMs, who can sign contracts. And some contracts, sometimes we'll do an interlocal cooperation agreement with another unit of government, and for some reason they want it to be signed by the mayor rather than the manager. And so what we're trying to do is clean this up to be more consistent with the current practice and what the state of the art is. We also eliminated the requirement to have the mayor or manager's signature attested, and that comes from the from the old days of wanting to verify that that was actually the mayor or the manager's signature on it. We're pretty sophisticated, and that's, I don't know that we, it kind of goes to the general law cities, or smaller cities where they don't have a big organization. They want to make sure that somebody didn't slip in and sign somebody else's signature there, so. But that's certainly policy, that's up to you.
A motion to accept 2102 and 2103 as stated, or as corrected?
Let me ask a question first.
Yes, sir.
The $10,000 limit is being removed. And of course, this was put in here back when $10,000 was a lot of money. And that's not so much on a contractual basis anymore. Is it the opinion of, let's see, I guess how to ask this question, is there anywhere else in the charter which puts some sort of a dollar restriction on what can and can't be approved by different levels within the organization?
The answer to that is yes, both by state law and by the administrative code.
Okay.
Administrative code gives the authority of the senior manager to sign contracts that have already been budgeted and approved by the council.
Okay, there we go.
And then the city manager has authority to let contracts for professional services, for infrastructure projects, and up to, I forget, 300,000, something like that. So
Okay.
there is express authority. And then on 2103, when you look at those two together, state law has a threshold which requires competitive bidding, and that has changed over the years. One time it was 25,000, now it's 50,000, and then there's various exceptions to that. So what we're trying to do is not hamper ourselves and impose greater restrictions on ourselves, and to be more consistent with what our current practice is.
Okay.
You keep this up, and people are going to look at our chart and go, "This is the way we should be doing it."
So, Mr. Chair, you're looking at 2102 and 03 together?
Yes, sir.
As a process question, I recommend that since we've done everyone separately, that we keep these.
That's fine. I was just going with what Pete said. He kind of put them together, but I think you're accurate. Let's do that. Let's get a motion for 2102.
I'll give a motion for 2102
As recommended.
as recommended.
As recommended, second by
Second.
Gerald. Okay, any further discussion? Show of hands in favor, please. Opposed? Seeing none, passes unanimously. Okay.
And then I'll recommend that 2103 moves forward as recommended.
Okay, motion on the table by Mark. Got a second by Jason. Any further discussions?
Yeah.
Okay, show of hands, all in favor? Passes unanimously. Okay, 21.04, acquisition of land for parks.
I want to know what pleasure ground.
I got that marked on mine too.
I wondered, but I didn't know.
Wow.
I'm not gonna get that definition.
I'll leave
Where are they?
2104
It's a
and
dog
the
park.
rest of those in 2102.
Well,
We didn't find anything inconsistent or contrary in the remaining part of Article 21, so we'll just try to answer questions. And like again, Bill, staying with that first premise,
I am curious, what is a pleasure ground? How is that defined?
I have no idea. It must have had some historical context at one time.
So do we need to strike it? Is it still relevant?
Would it be something like picnics and things like that? I don't know. I don't know what it is either. I underlined it if it makes anybody else feel good.
It's probably like a playground, because you have parks, parkways.
Well, like Ken said, a dog park. That makes sense, like a dog park.
Like amusement grounds that are owned
Well,
by
like a
municipality. I think Galveston owns.
As many
some
times
stuff
that I've
like
read
that.
this low pyramid, that I don't think pleasure grounds was ever listed. But since it was no harm, no foul,
It's got to be sports fields or something like that.
Any
Whatever you want, John.
It makes me afraid to take it out then.
We could change it to John's place.
Right, we'll have to take out the dog park.
Yeah.
Um, Pete, I had a question.
Yes, ma'am.
In another, let's see, and I'm going back and forth. In another couple of sections, we specifically added the word mayor. Is that not necessary in anything like, for example, in 2107, when we talk about that the city council has, the right to make those decisions? Do we need to add the mayor language in that, or just leave it as city council?
No, because the council acts through the city council, not just the mayor.
Okay, just wanted to make sure.
Yes, ma'am. Good point.
I'll go ahead and move approval for 2104.
You know what, let me,
You want to unmove my approval?
no, I agree with what you're headed to do here, but I just think that we ought to clean up some of this archaic language in here and say sports fields or something to kind of take the ambiguity out of that. In other words, really it's parks, but it's also parks and athletic facilities and
Nature preserves.
nature
like we just did.
preserves, it's hike and bike trails, whatever you want to call it, but something more definitive than pleasure grounds, I think would be a good change if we want to find something to replace that.
I did take the liberty of Googling it.
Oh, my gosh.
And
What
it is
it?
defined. I mean, at least
Oh, you did?
Wikipedia goes on to say, pleasure ground is an area of garden near to a building and landscape gardens of English style, blah, 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 blah,
Oh, now we know.
Now we know.
blah. So it's not as
It's not wrong.
Ominous.
explicit as we had it.
Yeah.
I think we're going to change it to something like athletic
Yeah,
complex
it's-
or something like that. Just
Sports fields.
Sports fields, something
Sporting
that
fields.
is a little more specific.
Well, sometimes you want to be more general.
Yeah, I was gonna
Yeah,
say, wouldn't it be
that's
better to
true.
be a little vague?
Does all of that come under the rubric of parks?
Parks, yes.
Yeah.
Or pleasure grounds.
Would this-
It's a
would
broader
this-
term.
It is a broad
Pleasure-
term.
Would this be
pleasure
applicable to
grounds.
something like Heights Rec Center? That'd be my question.
I'm sorry?
Would this, would section 2104, would it be applicable to something like Heights Rec? Well, or would it be, would it have to be?
Well, Heights Rec Center sits on the park, and we're talking about acquiring land.
Something that could.
So we acquired land for the park, and we happen to put a rec center on it. I'm guessing.
I mean, at that point, you own the land, so it doesn't.
Yeah, right, so I'm guessing parks is sufficiently broad.
And it goes on further to describe, if I'll just take from the time to short anyway. The pleasure ground is an area of garden near to a building in landscape gardens of English style that, in contrast to the outlying parts, stresses artistic elements over the more natural elements. And it's got some photos of what they describe on it. You can see that from here. But it's landscaping.
English gardens are organic.
Yeah.
yes.
Got it.
If you wanted to take over 2104, you could change parkways or pleasure grounds to, for use as parks, open space, or other recreational activities.
Yes.
But is it necessary to make the change?
No, because we have that authority under state law.
If
anyway.
we're tasked though as a committee to eliminate archaic language, this is, I think, a perfect example of language that you don't hear.
Right. I thought we were tasked to clean it up, change it where necessary, and do whatever our recommendation goes to the council, they can do with it as they will. Although I'd be very suspicious of anybody that wanted to keep pleasure grounds. Sorry.
Can you imagine the blogs?
Can you
Oh,
imagine?
my.
Council eliminates pleasure grounds.
What was your language? You recommended?
Parks, you would take
I-
out parkways.
I would take out parkways or pleasure grounds and replace that with open space or other recreational activities.
Or facility, recreational facilities.
No, this, we're getting the land. So
Grounds?
just-
Use.
There you go.
It's for use as a park,
Yeah.
open space, or other
Oh,
recreational,
yes,
Just
yes.
say other recreation.
Other recreational grounds.
other recreational activities.
Yeah.
Just for clarification, so we could appropriate land inside or outside of the city?
Yes, ma'am.
Can you give me an example of the outside of the city? Not that we have necessarily, but just an example
How
of
about the
what.
dog park, is that part of the plan?
No, we're on it.
This is not totally applicable, but would, you know how the city of Richardson shares with Plano, they share that police training facility that is technically in Plano. Now, obviously, that's not a pleasure ground, but.
I have a better example.
Okay.
I forget which, whether it's on, City of Dallas owns a farm and a park on the way, it's either to Terrell or Kaufman.
Yeah, it's off of 30.
Off of 30. And there's an example where the city has acquired property outside the city limits of Dallas, and it's used as a farm park. So,
Okay, so that's,
I can't think of any where the city hasn't acquired.
but that is a standard practice by cities.
It is, and it's authorized by state law.
Oh, okay.
So, I'll give you another example, although it's not really part, what used to be Chase Oaks Golf Course, which is in Plano. The city of Allen bought the property out of bankruptcy. And Plano won't disannex the property, so the Allen Golf Course could be in Allen. But there's an example where city owns property outside its city limits for recreational activities.
Thank you.
Courses at Waters Creek, I have to remember the right name of the course, formerly Chase Oaks.
Is Samuel Farm the name of that?
Yes, it is.
Samuel.
Yeah, thank you very much.
City does own property in Plano. The city does own property in Plano.
That's correct. We own a part of a railroad right of way in Plano, just north of Plano Parkway.
So the recommendation was that we change 2104 by deleting parkways or pleasure grounds and replacing that with open space or other recreational activities.
We have a motion.
What you said.
Erica? Okay, got a second?
I'll second.
Second. Laura? Any further discussion? Show of hands, please. Okay, passes unanimously. 21.05, Public Library.
Since this is one of my favorite subjects, the library, that is. I will point out that second phrase about to cooperate with any person, firm, or corporation under such terms, the city council may prescribe for the establishment of such public library or libraries is somewhat out of date. The library has not been at the grocery store at Main Street for 50-plus years. And it's a full-fledged, fully funded department of the city now, and so we really don't need to be cooperating with anybody to establish a library. So I know Pete doesn't want to make unnecessary edits, but that is language, I believe, that is totally unnecessary in today's charter.
Well, let me give you an example. Farmers Branch has a public library. They own the land, the building, but they have privatized the operation of the library. So they have a company that operates the library, even though it's the city's asset. So, but they'd have the right to do that, notwithstanding that language there. So, whatever you want to do in 2105 is your call. But there are situations where cities do privatize operations, and it could you know, I'm not speaking in particular of Farmers Branch, but it could be where city does not, and there's got to be a situation where city does not actually have a library, but has a contract with another city to go and use that.
Murphy does not have a library. They tell people to go to Richardson.
Yeah, and Addison uses Farmers Branch.
Yeah.
That's right.
Isn't this just to protect the concept of a public library will be publicly funded? Is that not the purpose?
Well, that's the free to the residents of the city of
Right,
Richardson.
exactly. So isn't that the crucial portion?
Yeah,
of
oh,
this?
sure, because that was a huge argument in 1988,
Yes.
whether it be called the Richardson Free Public Library. They had a big fight about that. They finally decided to take the word free out, but they obviously left in free in the charter, which I'm sure is everyone's intention.
Or it may be intended to cover a situation where someone says, I'll dedicate the land, I'll build you a building, provided you own and operate it as a public library. I don't know what the historical context is.
Well, that's an interesting point you make about perhaps opening a different kind of a library in cooperation with somebody like, say, UTD or something like that. So, fine, I'll let it go.
Okay, good discussion. Any motion?
So I'll provide the motion to keep it as is.
Okay. Second? Any further discussion? Show of hands in favor, please. Okay, passes unanimously. Thank you. Brings us 21.06, building permits.
It's gonna be the longest sentence ever. I have to read it 2 or 3 times.
Yes.
I was only about 4 years old when that was written, so.
Yeah, that's how long it took to write it. 4 years.
That's why when I took the LSAT, I decided I never wanted to be a lawyer.
I'd like to
Because
be
all the
short.
questions were like this.
I'd like to be short and precise, it's not what I would. But keeping with rule number 1, it's not in conflict, it's consistent with state law, consistent with our practices.
I move for approval as is.
Second, whatever. Discussion. All right, seeing none, all in favor? Passes unanimously. Section 2107.
I have to admit, and please tell me if I'm wrong, the first time I read this, does our charter require that every condemnation require a council vote? Is that how that reads?
This is, the answer is condemnation requires a resolution passed by the city council.
Okay, it does? Okay.
Yes.
And that's what we do right now?
Right. Absolutely.
Building and Standards Commission comes in.
Right.
But prior to condemnation, correct?
Right, so there are 2 different things. Here we're not talking about, we're not really talking about eminent domain, we're talking about condemning
Dangerous
unsafe
situation.
buildings, dangerous structures, which the Building Standards Commission hears those cases, and that's pursuant to state law.
So this has the effect of forcing a public discussion on every condemnation, which is probably what people want.
Not this section, but the other section does, because the section we have on condemnation, the state law requires the council to pass a resolution and declare what the public necessity is. And obviously that has to be done in an open session. It
So-
requires us to have an appraisal and make an offer. There's a bill of rights to property owners, and they have to be afforded a copy of the appraisal and be notified that we have an eminent domain power and we'll think about condemning the property.
Are we saying that 2107 is duplicated someplace else as well?
No, this just has to do with substandard buildings, really.
And the other thing you just referred to?
It's just condemning property for the purposes of using it for public purpose. Here we're talking about condemning property, saying you can't live there anymore. Got to close it, got to fix it, got to repair it.
Right.
And we do have authority under state law to, we go through the Building Standards Commission even before we have that process, to put liens on the property if we go in and repair or demolish, and actually sue to foreclose those liens and acquire the property as we did on Spring Valley years and years ago. So it's not broke, it's not inconsistent.
No, I think it's fine. Anything that forces, we don't want to take or even horribly abuse property without public hearing, so I think this is fine.
And I don't want to cloud the issue, but I guess my question would be, Pete, do we need to say who brings this to the city council? Like the building code or the inspectors or whatever? I guess what I'm saying is, if we're talking about the city council making this decision and saying, we're going to shut this down, but they're not out looking at those buildings most likely, and they don't have the expertise most likely to determine that that is an unsafe building. Is it necessary to say as presented by a particular part of the city? You know, does that make sense, or does it matter? I may be adding too much to it.
It's usually either the health department, because of substandard health conditions, backed up toilets, things like that, or it's building inspectors who go out there and determine a balcony is not safe to be standing on, that sort of thing. So it comes into the city through the buildings and standards, which then makes a recommendation to the city council as to how to proceed. The council then takes either condemnation action, or they have been known to work with folks who are in the process of wanting to fix up and spend money, but it takes a commitment of time will be spent, something like that. So that's the process.
I guess what I was thinking, John, is it possible, I mean, I walk into a city council meeting and I ask for my 3 minutes to stand up and I say that my neighbor's home needs to be condemned. And the city council listens to me and they say, okay, it's condemned. Or does it have to, I mean, I know that that's far-fetched.
They'll give it to the city manager, who will then send out those people to investigate and determine is that.
Does it, do we need to put that in? I guess what I'm saying, is there someone that could have an agenda that would come forward? I don't know, it's hypothetical is all I'm saying.
They say something during the public comment of a council meeting. I don't know that there's any action that can be taken at that point.
Not at all.
I think by putting that process in there, you're restricting it to that process, leaving it open like this. However it comes to the city council, I think it's better to leave it broad like that. The
Okay.
city has a process.
And the
I'm
city,
good.
city has, we have ordinances in place that authorize the code enforcement officials to send notice, and so consistent with that authority here, we have an ordinance in place, so the council has already authorized administrative officials to take the action, initiate the process and that, so. But your point, I understand your confusion there, and I was rereading that, thinking about whether we should change that at all.
I think the purpose is to make sure that on a condemnation, the council takes the responsibility. The city manager can't do it, the boards and commissions, the building standards can't do it. No department, the council has to do it, and that's the intent of that section. And how that happens, I'm not so concerned.
But that's covered by the section on eminent domain. This is talking about dangerous structures. This is talking about what goes on with Building Standards Commission. We do an inspection, we find it's uninhabitable. The building official sends out notice, you gotta fix it, repair it, shut it down. They don't do it, and we take the action to make it safe or tear it down, then we can impose liens against the property, and then we can foreclose that. And obviously, the city's not foreclosing the lien and suing, the council's gonna have to authorize that.
All pursuant to police powers.
Yes, sir.
Okay. We got a motion to approve as written.
So moved.
Okay, Gerald. Second by Jason. Any further discussion?
Let's just add an E to the end of therefore on the last sentence.
I'm sorry?
Therefore is misspelled.
Isn't that an archaic spelling?
Well, it's consistent without an airport.
Yeah, I think that's an archaic spelling.
I need to make a
It's
note.
been propagated.
As we look at the city, lowercase versus uppercase.
So that's
as
another
well,
one,
so
I'm making a list, so therefore,
Global change of therefore.
therefore, okay.
Maybe Ron can find it with
It's
you.
just therefore.
Check it right now.
I don't even.
At least there's no reference to castles in that paragraph.
You're still on
It
Fleming.
was surrounding.
Yeah.
Where is it?
Very last, next, 3 words from the end.
I'm sorry,
Also
yes.
sleeping center.
Okay.
I'm surprised I didn't find that on the original.
Oh, I think that's a legitimate archaic spelling.
It is. If we're updating.
Just say that for when we come back
For
again,
Bloom.
to
With uppercase,
Oh.
lowercase city.
do a global
Yes.
change, shall
Yeah.
city be capitalized in every section and so
Yeah.
forth.
Okay, we have a motion on 2107.
Yes, you already have one.
Yep.
Okay,
Motion and
and
second.
and a second. All right, anything else? Okay, all in favor, show of hands, please. Passes unanimously. Thank you. 21.08. Appears to be no recommendation as far as changes. Any discussion?
Do we actually do this?
Yes, sir.
We actually require bonds, and the city pays the premium?
Yes, for certain positions.
Well, that's cool.
CFO for one.
Yeah, typically for your finance.
We're gonna require you to post a bond, but we'll pay your premium. Well, that's a deal. I take it this is in every other charter in every city around here. Yeah.
It's pretty typical.
Yeah.
And in most businesses and industries, the companies pay the bond of their employees as well.
I guess-
Just to clarify.
Sounds like a racket to me.
After all, it's insurance for the employee.
Well,
Yeah,
sure,
the
sure,
good of the
sure,
business.
sure.
So I'll make a motion to keep it as is.
Okay, got a motion by Mark, second. Second. Any further discussion? Okay, all in favor, show of hands, please. Passes unanimously. All right, before we close out, we wanted to capture cities and therefores and so forth, is that right?
I think we wait till the end of our review.
At the very end of the review,
Yeah.
not,
Yes.
not
We'll all
at this
forget,
point.
right?
Because
Okay.
I'm sure there'll be other words and phrases.
Somebody's
Okay,
keeping
I
notes.
got it.
I am.
You have a list.
I've got my global.
I already have the list.
Well,
Perfect.
yeah.
Okay.
I have a question.
Yes, ma'am.
What about the handouts we got from the public hearing, and how will we process the information we got from that?
Amy has those, and she'll pass them out before the end of the meeting, and then, when those topics come up, you know,
Well,
'cause
there
we'll talk
were
about.
several topics that came up, and some of which seems like aren't even in here. So do we wait till the end to talk about them, or do we talk about them
Well,
to see maybe whether we want to talk about them or discuss them further?
well,
Or
I would.
how do we handle it? Is my
I
question.
would suggest we deal with them as those topics come up, and then the ones that don't seem to relate at all, like Mr. Newton's about the proclamation, and say that to the end if we want to, because there's nothing existing in the charter that we would relate to, but you heard the item about staggered terms and term limits.
Yeah, and the charter review.
The charter review's not in the charter, I don't think.
No, so that might be
Yeah,
something at
that-
the end.
that's something at the
Right.
end, yeah.
So the term
We'll
limits.
we'll have an opportunity when we get to that section of the charter that
Mhm.
talks about term amendments.
Okay. Passed out to you a couple of documents. This document here, this came across electronically to Amy, and it was a comment. So it's just the only comment that we've received electronically. It's just for y'all to read, look at, give thought to. Okay?
Now, will we continue to get those, or was it just for the public hearing that you allowed
This
this?
is on our website.
So it'll continue, we'll continue, okay, got it.
If you'll recall, when we had the original dialogue earlier, when we said that anything that came through electronically, it would go to Amy, Amy would then share it with us, as opposed to going out to all of us.
Yeah.
So she's collecting those, and that's where we are there. Let's look at, our schedule. We passed the schedule back out. And our next meeting, November 12th, we have changed the order in which we were going to address a couple of items. We flip-flopped November 12 agenda, talking about the nomination and election of city council to the boards and commission civil services. We're flip-flopping those on the agenda. Hopefully that will allow us to feel more comfortable with the process. That topic on November 12th originally, that may be a little soon for us to really get into it. There's a lot of passion about that. There's a lot of, thoughts about that. So we're going to move that down, and we want to make sure that everybody's here for those. And I think it'll be a great night, good dialogue at that point. So that is what we've done. And then I believe that's anything else I need to cover as far as other business? I don't see anything. I think we have.
I believe John's going to invite us all over to his pleasure grounds after.
And watch the fried tickets.
That's in Heights Park, because that's where we're supposed to be. So.
All right. Hey, I commend all of y'all. It was a great night. Like we talked about as far as procedure, hey, y'all played fair. We had fun. It was some great dialogue. So congratulations. If we get a motion to adjourn, I would appreciate it.
So we adjourn.
All right, Ron, and a second by Bill. All in all in favor? All right, we are officially adjourned. Thank y'all very much.
Thank you.
Okay.
Our next meeting is 6 p.m. on November 12th. Next Wednesday.
Articles 9 and 10.
I mean, I've got a couple hanging out.
Oh yeah, these are from tonight.
Actually, I'll just start counting.
Let's do it.
Okay.
Yeah.
Oh, we'll take one. Yeah.
Okay, this.
And here's
Okay.
Oh, this is very messy. Okay. So number 6.
Coming around, Gerald?
Yep.
Thank you.
So you should be getting 3 handouts, well, 2 handouts and 1 card,
Thank you,
so.
Charlie. Okay. Oh, you already have that. Okay, so we
Thank you. So did everyone get this one?
Yes.
Okay.
Yes.
And you have to do this one?
No, my dear, there's another one coming this way.
Yep, there's one.
I need the
Oh, the League of Women.
Yes,
We ran
we-
out right here.
Yes,
That's
you guys
perfect.
ran out, okay.
Thank you.
Got it.
And then
Can
we
I
have
have a
these.
copy?
You got those ones?
Yes, we
Okay,
got
so you got
these.
3 total, okay.
And the email one too?
Yes.
Drew, that way, we'll talk about 2 of them.
It's on the second page.
As you said, most of the stuff's already
Cracking
done.
out this, send them to me. I'm trying to be very restrictive with that change.
Most of this is already done.
Good night.
See you later.
I thought this was the league, was there a legal women voters?
Oh, yeah, I only have 1 copy, I can go make you one.
Okay.
This was the comment, it's not related to the charter, but that's what came in.
Bye-bye. Bye-bye.